Picture returning home after 9 months overseas, serving your country in a combat zone, only to discover a legal notice taped to your front door. Not a welcome home message. Not a thank you for your service. Instead, a document informing you that your property was being taken away, and the people behind it weren't the government or a lender. It was your HOA. Worse yet, they had been working toward it the entire time you were gone. Before we go any further, let me know where you're watching from by commenting your country below. I always enjoy seeing how far these stories reach. Marcus Webb had spent 11 years serving in the United States Army. He wasn't someone who made excuses or looked for sympathy. He handled problems, followed orders, and focused on a mission in front of him when he purchased a 2-acre property on the edge of Pinewood Estates, a peaceful semi-rural neighborhood in central Tennessee. He believed he had finally found a place to call his own. The property wasn't extravagant. It had a modest home, a detached workshop, and a small vegetable garden that his grandmother had helped him build the summer before she passed away. It wasn't impressive to outsiders, but to Marcus, it meant everything. In March, he was deployed overseas. Before leaving, Marcus made sure every detail was handled properly. He prepaid 6 months of HOA dues. He arranged for his friend and neighbor, Dale, to mow the lawn every other week. He also sent written notice to the HOA management office through certified mail explaining that he would be on active deployment and could be unreachable for extended periods of time. To make matters even clearer, he included the contact information for his military JAG officer in case any issue came up while he was away. Marcus did everything exactly the way he was supposed to. That's what makes the next part so unbelievable. The first violation letter arrived in April, barely a month after he deployed. According to the HOA, there was overgrown vegetation along the eastern fence line. Dale had been maintaining the lawn just as promised, but the wildflowers Marcus' grandmother had planted years earlier had blossomed ahead of schedule that spring. Tall pink and white flowers stretched along the fence. Apparently, HOA President Linda Marsh considered them a problem. 3 weeks later, another violation notice arrived. This time, the HOA claimed Marcus had an unauthorized structure on his property. The structure in question was his grandmother's garden shed. The shed had stood there for more than 20 years. In fact, it had existed long before Pinewood Estates HOA had ever been established. Dale attempted to contact the HOA office to clear things up. He left 3 separate voicemails. No one returned a single call. By June, the penalties were piling up. $75 here, $150 there. And here's the part that should really make you angry. Marcus wasn't seeing any of these notices as they arrived. The mail was being forwarded to a post office box managed by his sister, Sarah. But Sarah was dealing with a difficult pregnancy and had little time to sort through stacks of paperwork. Week after week, the letters remained unopened on her kitchen counter. The HOA knew Marcus was deployed. They had received official written notice. Yet they continued issuing violations and fines anyway. By August, those fines and administrative fees had climbed past $4,200. That's when Linda Marsh decided to take things even further. The HOA filed a lien against Marcus' property. Then, unbelievably, they petitioned the county court to begin foreclosure proceedings against his home. Think about that for a moment. A soldier serving overseas was at risk of losing his house while defending his country. In early September, just 3 days after giving birth, Sarah finally began sorting through the mountain of mail that had accumulated over the previous months. Buried between a utility bill and a grocery advertisement was a court summons. She immediately tried to contact her brother. Because Marcus was deployed, it took nearly 2 days for the message to reach him through official military channels. When he finally heard Sarah's trembling voice on the phone and listened as she read the words foreclosure proceedings, Marcus Webb, a man who had remained calm under enemy fire, sat silently for several long seconds. Finally, he spoke. "Give me a lawyer." His JAG officer referred him to a civilian attorney named Patricia Cole. Patricia had spent the last 15 years specializing almost exclusively in HOA law. After Sarah emailed her every document, the deployment orders, proof of prepaid dues, certified mail receipts, and violation notices, Patricia reviewed the entire file carefully. When she finished, she immediately called Sarah back. "Tell your brother something," she said. Linda Marsh just made the biggest mistake of her life. Patricia had already spotted the problem. The Service Member Civil Relief Act, commonly known as the SCRA, is a federal law that grants extensive legal protections to active duty military personnel. It can limit interest charges, delay civil legal actions, and protects service members from certain proceedings while they are deployed. And most importantly, the law specifically prevents foreclosure actions against active duty service members unless a court issues an order that fully considers their military status. The HOA had never obtained such an order. They moved forward with foreclosure despite knowing Marcus was deployed. They had written proof of his deployment sitting in their files and chose to proceed anyway. That wasn't merely a civil mistake. It was a violation of federal law. Patricia wasted no time. Within the same week, she filed an emergency motion to stop the foreclosure process. The court approved it within 48 hours. Then she went on the offensive. On Marcus' behalf, Patricia filed a countersuit alleging violations of the SCRA, bad faith conduct by the HOA, and intentional infliction of emotional distress. A hearing was scheduled for November. Marcus was granted emergency leave and flew home. The day of the hearing, he walked into the courtroom wearing his Army dress uniform. Not because he wanted attention, he would later explain, but because his travel schedule had been so tight that he barely had time to make it there. Across the courtroom sat Linda Marsh. Beside her was the HOA's attorney, Gerald Potts, a lawyer whose practice focused heavily on community association disputes. When the proceedings began, he appeared completely confident. By the end of the day, that confidence had vanished. Patricia presented her case piece by piece. She introduced the certified mail receipts. She presented records showing Marcus had prepaid his HOA dues. She submitted copies of his deployment notification. Then she walked the court through the timeline of violations and fines, beginning with the first citation issued only 28 days after Marcus had left the country. But then she introduced evidence that changed the entire atmosphere in the room. During her preparation, Patricia had obtained complete HOA violation records for every property inside Pinewood Estates covering the previous 3 years. Originally, she was searching for signs of selective enforcement. What she uncovered was remarkable. Linda Marsh's own property had accumulated 3 documented violations. One of them involved an unapproved deck addition that was substantially larger than the garden shed the HOA had cited on Marcus' property. Yet none of those violations had resulted in penalties. Not one warning, not one fine, not $1 collected. The evidence painted a clear picture. The HOA president had aggressively enforced rules against a deployed soldier while completely ignoring violations on her own property. The judge, who happened to be a former Navy veteran, reviewed the documents carefully. Then he looked over the top of his glasses at Linda Marsh. The courtroom remained silent for several long moments. When he finally ruled, he ruled entirely in Marcus' favor. Every claim, every issue, every count. The foreclosure action was permanently dismissed. All accumulated fines were voided. The lien against Marcus' property was removed. And because of the federal SCRA violations, the HOA was ordered to pay Marcus $31,000 in damages, including attorney fees, statutory penalties, and compensation for emotional distress. But the consequences didn't stop there. The judge took an additional step. He referred the matter to the state attorney general's office for a formal review of the HOA's governance and enforcement practices. The fallout came quickly. Within 3 months, Linda Marsh resigned from the board. 2 additional board members stepped down shortly afterward. The HOA itself was placed under supervised administrative review. As for Marcus, he finally returned home. On a cold afternoon in December, he walked slowly along the fence line surrounding his property. The wildflowers that had started the entire dispute were gone for the winter. They had been cut down months earlier during the conflict, but their roots remained. His grandmother had planted them deeply. Standing there in the cold, Marcus was already thinking ahead to spring and how they would bloom again. And that's the lesson I want to leave you with. Marcus didn't prevail because of luck. He didn't win because someone felt sorry for him. He won because he had something Linda Marsh never expected him to have: documentation. Every precaution he took before deploying was deliberate. Every receipt, every letter, every record. When someone tried to take advantage of his absence, that paper trail spoke louder than any argument ever could. So here's something worth thinking about. How many homeowners never meet a Patricia Cole? How many service members or ordinary families lose their homes simply because they don't know the rights they already have? Let me know your thoughts in the comments below. And if this story made your blood pressure rise even a little, consider sharing it. Someone out there may need to learn that these protections exist before it's too late.